Everyone knew him as Hollywood's golden boy, the pretty face of Tinseltown. But when Brad Pitt stood up in federal court that day, he was about to reveal a secret that would shatter every assumption about him. Not just movie star charisma, but devastating constitutional law expertise that had been hidden behind those famous blue eyes for over 2 decades. Judge Samuel Alito was smirking, ready to dismiss him as just another actor playing lawyer, completely unaware that standing before him was a constitutional scholar who understood the Bill of Rights better than most Supreme Court clerks. What happened next would leave the entire courtroom speechless and redefine everything people thought they knew about Brad Pitt. "Your Honor, Judge Alito," said Pitt, his voice carrying that familiar charm but now laser-focused with legal precision, "may I speak to you about the 14th Amendment's Due Process Clause and how it applies to this case?" The silence that followed was deafening. This wasn't supposed to happen. Hollywood pretty boys don't quote constitutional amendments. But then again, Brad Pitt had never been just another pretty boy. Alito's world, conservative judicial supremacy, Judge Samuel Anthony Alito Jr. sat behind the bench like a fortress of conservative legal tradition. At 74, he had spent decades building his reputation as an unwavering originalist, someone who believed the Constitution meant exactly what it said when it was written. Nothing more, nothing less. A Princeton undergraduate, Yale Law graduate, and Supreme Court Justice since 2006, Alito embodied everything traditional about American jurisprudence. His courtroom was his kingdom, and he ruled it with an iron fist wrapped in black robes. Alito had little patience for what he saw as liberal judicial activism, celebrity grandstanding, or anyone who dared challenge his interpretation of constitutional law. Today, he expected to make quick work of whatever theatrical performance this Hollywood actor had prepared. Pitt's hidden journey. From pretty boy to constitutional scholar, the world knew Brad Pitt as the face that launched 1,000 movie posters, from Thelma and Louise heartthrob to Fight Club anarchist, from Ocean's 11 charmer to Once Upon a Time in Hollywood icon. His face had defined Hollywood glamour for 3 decades. But behind those famous features lay a mind that had been quietly absorbing constitutional law like a sponge. It started in 1995 during the filming of Seven. Between takes of that dark thriller, Pitt found himself reading legal briefs instead of scripts. "I realized I was playing characters making moral decisions without understanding the legal framework that governs real moral decisions," he had confided to his then-wife Jennifer Aniston during their marriage. What began as curiosity became obsession. Pitt spent his downtime between films not at parties or premieres, but in law libraries. He completed constitutional law courses at UCLA, studied under Professor Erwin Chemerinsky, and spent years analyzing Supreme Court decisions with the same intensity he brought to character preparation. By 2024, Brad Pitt wasn't just an actor who played lawyers. He had become a lawyer who happened to act. Deal. Celebrity versus constitutional rights. The case that brought Pitt to Alito's courtroom was deceptively simple but constitutionally explosive. Pitt via's Department of Homeland Security challenged the government's use of celebrity surveillance programs that monitored famous individuals without warrants, claiming national security interests justified the constitutional violation. Pitt had discovered through a Freedom of Information Act request that federal agencies had been tracking his movements, recording his conversations, and monitoring his associations for over a decade, all without judicial oversight. The government claimed his celebrity status and international travel made him a potential national security risk requiring enhanced surveillance. For Alito, this was a straightforward case of national security trumping individual privacy rights. For Pitt, it was about the fundamental principle that constitutional rights don't disappear just because you're famous. "The dismissive opening, Mr. Pitt," Alito began, his voice dripping with barely concealed condescension. "I'm sure your acting experience has given you some familiarity with legal dramas. However, this is a real courtroom dealing with real constitutional questions that require actual legal expertise. Are you certain you're prepared to engage with the complexities of Fourth Amendment jurisprudence, or would you prefer to let your actual attorneys handle this matter?" The question hung in the air like a gauntlet thrown down. Alito's message was clear. Stick to your day job, pretty boy. Pitt stood slowly, and for a moment, that famous smile flickered across his face. But when he spoke, every trace of Hollywood charm was replaced by razor-sharp legal acuity. Your Honor, I appreciate your concern about my qualifications. However, I believe the Fourth Amendment's prohibition against unreasonable searches and seizures applies to all American citizens, regardless of their profession. The government's warrantless surveillance program violates not just my rights, but the constitutional principles that protect every person in this courtroom. Alito's smirk faltered. This wasn't the fumbling celebrity performance he'd expected. The constitutional gauntlet, Mr. Pitt, Alito continued, now with genuine interest creeping into his voice. Citing the Fourth Amendment is elementary. Understanding how it applies to modern surveillance technology and national security concerns requires sophisticated legal analysis. Are you familiar with the Supreme Court's decision in United States v. Jones and its implications for digital surveillance? This was Alito's test. Jones was a complex case that most lawyers struggled with. Surely this would expose Pitt's legal amateur status. Pitt didn't hesitate. Absolutely, Your Honor. Jones established that attaching a GPS device to a vehicle constitutes a search under the Fourth Amendment, but more importantly, Justice Sotomayor's concurrence recognized that long-term surveillance can violate reasonable expectations of privacy even without physical trespass. The government's surveillance of me involves exactly this kind of long-term monitoring that Justice Sotomayor warned against. The courtroom stirred. This wasn't legal theater. This was serious constitutional analysis. The revelation unfolds furthermore, Pitt continued, gaining momentum. The court's subsequent decision in Carpenter v. United States extended Jones by requiring warrants for accessing cell phone location data. If the government needs a warrant to track someone's phone, how can they justify warrantless surveillance of my entire life simply because I'm recognizable? Alito leaned forward, his dismissive attitude evaporating. Mr. Pitt, where exactly did you develop this understanding of Fourth Amendment jurisprudence? I've spent the last 29 years studying constitutional law, Your Honor. I completed advanced courses at UCLA Law, studied under Professor Chemerinsky at Berkeley, and worked with constitutional scholars at Harvard. I've read every major Fourth Amendment decision since Katz v. United States, and I can tell you that what the government is doing to me would be unconstitutional if done to any other citizen. The courtroom erupted in whispers. Alito hammered his gavel for silence, his expression now one of genuine surprise and growing respect. The constitutional masterclass. Let me be more specific, Pitt said, pulling out a thick legal brief. The government claims celebrity status creates special national security concerns, but in Laird v. Tatum, this court held that surveillance for its own sake, without specific evidence of wrongdoing, violates the First Amendment's protection of free association. My celebrity status doesn't forfeit my constitutional rights. Alito found himself taking notes. Continue. Moreover, in United States v. U.S. District Court, the Keith case, the court specifically rejected the government's claim that national security concerns justify warrantless surveillance of domestic activities. Unless the government can show I'm an agent of a foreign power, which they can't, their surveillance program is unconstitutional. Pitt then delivered what would become the hearing's most quoted moment. Your Honor, the Constitution doesn't have a celebrity exception. The Fourth Amendment doesn't say the right of the people to be secure in their persons, houses, papers, and effects shall not be violated unless they're movie stars. If we allow the government to strip constitutional rights from famous people, how long before they strip them from everyone else? Alito's transformation. The change in Judge Alito was visible to everyone present. The man who had entered the courtroom ready to lecture a Hollywood actor was now engaged in serious constitutional dialogue with someone who clearly understood the law as well as he did. Mr. Pitt, Alito said, his voice now carrying genuine respect, your constitutional analysis is remarkably sophisticated. You've presented Fourth Amendment arguments that would be impressive coming from any Supreme Court advocate. Thank you, Your Honor. But this case isn't about impressing anyone. It's about the principle that constitutional rights belong to all Americans, whether they're anonymous or famous, whether they work in factories or on film sets. The government's last stand. The Department of Homeland Security's attorney, clearly rattled by Pitt's unexpected expertise, attempted one final argument. Your Honor, Mr. Pitt's celebrity status makes him a uniquely valuable target for foreign intelligence services. Enhanced surveillance is a reasonable security measure. Pitt was ready. Your Honor, that argument would allow the government to surveil anyone they deem uniquely valuable: CEOs, scientists, journalists, politicians. It's exactly the kind of general warrant that the Fourth Amendment was designed to prevent. As Justice Jackson wrote in Johnson v. United States, the point of the Fourth Amendment is not that it denies law enforcement the support of the usual inferences which reasonable men draw from evidence. Its protection consists in requiring that those inferences be drawn by a neutral and detached magistrate, instead of being judged by the officer engaged in the often competitive enterprise of ferreting out crime. The landmark decision, Judge Alito's ruling, came 3 weeks later, a comprehensive victory for Pitt and constitutional rights. But more than the legal victory was Alito's remarkable acknowledgement in his written opinion. This case serves as a reminder that constitutional wisdom can emerge from unexpected sources. Mr. Pitt's analysis of Fourth Amendment jurisprudence was not only legally sound, but demonstrated a deep understanding of the constitutional principles that protect all Americans. His argument that celebrity status cannot justify the suspension of constitutional rights is both legally correct and fundamentally American. The broader impact, the Pitt vs. DHS decision became required reading in constitutional law classes across the country. Law schools began inviting Pitt to speak, not as a celebrity guest, but as a serious constitutional scholar. The case established the Pitt principle that no one's celebrity status justifies the government suspending their constitutional rights. More importantly, it revealed that behind Hollywood's pretty faces could lie serious minds engaged with the most important questions facing American democracy. If you found this incredible fictional story of hidden brilliance and constitutional courage inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging the most powerful institutions. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge can emerge from the most surprising places. What did you think of this fictional portrayal of Brad Pitt's constitutional expertise? Share your thoughts in the comments below. Important note: this is a completely fictional story created for entertainment purposes. Any resemblance to real events or persons is purely coincidental.